Hello everyone, I'm Maharashtra and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court and then cover High Courts and other lower courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. The Supreme Court today asked the Union government to hold meetings between the states of Punjab and Haryana to resolve the dispute related to the Sutlej-Yamuna link canal. A bench comprising Justices Sanjay Kishan Kaul, Abhay S. Oka and Vikram Nath was hearing an original suit filed by Haryana against Punjab in 1996. Appearing for the Union government, Attorney General for India K.K. Venugopal submitted that the Ministry of Jal Shakti is trying to bring together the state of Punjab and the state of Haryana. The Attorney General further informed that the state of Punjab is not cooperating in this matter. At this, the court directed all the parties to cooperate. The Supreme Court today asked the Union government to hold talks between the states of Orissa, Andhra Pradesh and Chhattisgarh for the resolution of the Polavaram Dam and Godavari River water dispute. During the proceedings, it was submitted by Senior Advocate Gopal Subramaniam that the project being undertaken by Andhra Pradesh is in violation of the recommendations of the Justice Bachawat panel. The counsel appearing for Andhra Pradesh during the proceedings submitted that there has not been a consensus between the states and that ₹30,000 crores has been spent so far. Accordingly, a bench comprising Justices Sanjay Kishan Kaul, Abhay S. Oka and Vikram Nath suggested that a meeting should be held with the Chief Secretaries of the state. The Supreme Court of India today commenced hearing on the issue as to whether rules of the game can be changed after the selection process has already started. The issue arose in a batch of cases relating to the selection process of district judges conducted by certain high courts. The primary question was whether the selection criteria can be changed during the process. At the outset, the 5-judge Constitution bench of Justices Indira Banerjee, Hemant Gupta, Surya Kant, M.M. Sundaresh and Sudhanshu Dhulia posed to the advocates appearing in the matter, and I quote, "When there is a change in rules with respect to qualification eligibility, then you can say there is a change in rules. But based upon contingency, if the number of persons to be called for interview are increased or decreased, would that amount to change in rules?" The Supreme Court today suggested the Union government to be sensitive while dealing with the applications filed by physically disabled persons who had cleared the Civil Services examination to apply for the Indian Police Service, Indian Railways Protection Force Service and Daman and Diu, Dadra and Nagar Haveli, Andaman and Nicobar Islands and Lakshadweep Police Services. The court was hearing a petition filed by the NGO National Platform for the Rights of the Disabled, challenging the blanket exclusion of disabled people from these forces. On March 25th, by way of an interim order, the court had allowed physically disabled persons who have cleared the Civil Services examination to apply provisionally to these examinations. The Supreme Court has dismissed an appeal filed by former IPS officer Sanjeev Bhatt assailing the order passed by the High Court of Gujarat, by which the High Court had refused to quash a complaint filed against him. The bench disposed of the special leave petition and noted in its order that they found no reason to interfere with the matter. The complaint filed against former IPS officer is one of the 3 complaints filed by 3 persons who had accused Bhatt and his colleagues of illegal detention as well as custodial torture in a case related to unlawful assembly back in 1990. Today's Supreme Court Judge Justice D.Y. Chandrachud, who has been advocating the use of technology in legal proceedings for quite some time now, made some interesting remarks on the use of electronic devices in courtrooms. During the course of a hearing today, Senior Advocate Vijay Hansaria apprised Justice Chandrachud that he has been told that the judges of high courts and subordinate judiciary do not encourage the use of phones inside the courtrooms. Indicating that there should be a change in this particular mindset, Justice Chandrachud narrated an incident where he found someone recording what was being said in his courtroom. He remarked that instead of taking the traditional view on this issue, he had reflected that if something is being said in open court, then there is no harm in recording it. However, he added a caveat that one should refrain from prying into the discussions that the judges have amongst themselves during the course of the hearing. Chief Justice of India UU Lalit today indicated that the Supreme Court Constitution Bench might take up tomorrow the cases related to the rift within the Shiv Sena party and the consequential political developments in the state of Maharashtra. This was after senior advocate Neeraj Kishan Kaul, representing the Eknath Shinde group, sought an urgent hearing of the matter by stating that the proceedings before the Election Commission of India to determine the real Shiv Sena have been stalled. The cases were referred to a constitution bench by a 3-judge bench on August 24th. I can't say of the cutoff, but certainly by tomorrow something will be there, CJI Lalit remarked today during the hearing. The Supreme Court today issued notice to the state of Uttar Pradesh in the petition filed by Ashish Mishra, the son of Union Minister Ajay Kumar Mishra, in the Lakhimpur Kheri violence case. A bench comprising Justices Indira Banerjee, M.M. Sundaresh was considering the petition filed by Mishra challenging the July 26th order of the Allahabad High Court, which had dismissed his regular bail application. The state has been asked to file its response by September 26th. Senior advocate Mukul Rohatgi, appearing for Mishra, submitted today that the allegation was that Mishra mowed down people with the vehicle, but the vehicle was driven by his driver. The Supreme Court has asked the union government to get in touch with the chief secretaries of the states where FIRs under Section 66A of the Information Technology Act are continuing to be registered despite the provision being declared unconstitutional by the Supreme Court in 2015. The court asked the union to impress upon such states to take remedial measures as soon as possible. A bench comprising Chief Justice of India UU Lalit and Justice S. Ravinder Bhatt was hearing a writ petition filed by the NGO PUCL, which highlighted the issue of Section 66A of the IT Act being invoked despite the judgment in Shreya Singhal versus Union of India. After noting that the matter was extremely serious, the court issued notice to the states and the high courts. The matter will now be heard 3 weeks later. The Supreme Court Constitution Bench today took up the cases challenging the constitutional validity of reservation for economically weaker sections. In the last hearing, the 5-judge bench comprising Chief Justice of India UU Lalit, Justices Dinesh Maheshwari, S. Ravinder Bhatt, Bela M. Trivedi and J.B. Pardiwala had decided to list the matter for today to set the timeline for hearing and completion of other pre-hearing steps. The bench had also stated that the hearing in the matters will commence from September 13th. Today, the Chief Justice of India said in court that the court would complete hearing the matter within 5 working days and accordingly listed the matter for further hearing on September 13th. The UP government has told the Supreme Court that Kerala journalist Siddique Kappan, who is in custody since October 2020 in connection with the Hathras conspiracy case, has deep links with terror funding organizations like the Popular Front of India, that is the PFI, and its student wing Campus Front of India. These organizations have allegedly been found to have connections with Al-Qaeda and other terrorist organizations. In its counter affidavit opposing the grant of bail to Kappan, the government has said that Kappan's pleadings before the court are riddled with falsehoods, contradictions and suppression of facts. From claiming that the petitioners are politically motivated to stating that the legislature's motive in enacting a law cannot be questioned, the central government has filed a comprehensive counter affidavit supporting the extension of tenure given to the director of the Directorate Enforcement, that is the ED. The affidavit came in response to a batch of petitions challenging the extension given to the director of the ED. The petitions had also challenged the Central Vigilance Commission Amendment Act of 2021, which allows the extension of the term of the director of the Enforcement Directorate up to 5 years. In the counter affidavit, the ED has stated that the present writ petition styled as a PIL is not maintainable as it stems from a political motive. It further states that for an Article 32 petition to be maintainable, there has to be a violation of the fundamental right under Part 3 of the Constitution, which is not the case. The Madhya Pradesh High Court recently dismissed a petition filed in the form of a public interest litigation petition seeking directions to make available answer scripts of all the candidates who have appeared for the mains written examination of the lower judiciary examination in the state. Rejecting the contentions raised by the petitioner, the division bench comprising Justice Sheel Nagu and Justice D.D. Bansal observed that making the answer sheets of a candidate available to the public would violate their right to privacy and would also be against public interest. A public interest petition has been moved before the Calcutta High Court seeking a probe by the Central Bureau of Investigation, that is the CBI, as to why the leader of the opposition in the State Assembly, Suvenendu Adhikari's convoy, got involved in multiple accidents of late. The PIL has been moved by a practicing advocate of the Calcutta High Court named Ravi Ranjan Kumar, alleging that a plan to assassinate Adhikari, a Z category VIP security cover holder, is cooking and that the police are remaining silent for the reasons best known to them. The petition has also alleged that there has been various planned attacks on the life of the leader of the opposition and that there have been incidents where the convoy of Adhikari has been put into danger and that these incidents must be investigated by the CBI. The Allahabad High Court today confirmed the death penalty awarded to a man who has committed the murder of his wife and children on account of an illicit relationship with his sister-in-law back in the year 2009. The bench of Justice Ramesh Sinha and Justice Saroj Yadav concluded that in view of the manner in which the offence was committed and also the magnitude of the crime, it could be placed under the category of antisocial or socially abhorrent nature of crime. With this, the High Court concurred with the finding of the trial court that the convict had killed 6 persons in the most brutal manner, which calls for exemplary punishment. Thank you so much for joining us in this episode. If you like our content, please do not forget to support us by liking and subscribing to our YouTube channel. See you tomorrow.